Hello and welcome to Wide Angle This Week. On Monday, the 28th of August, the Pune police, in what they called multi-city arrests, or tried to detain 5 human rights activists in different parts of the country. They claim that these individuals were part of a larger Maoist plot. But overall, the evidence that they have provided is next to nothing. Joining us to talk about the case, the charges, what it means for these individuals and what it means for the larger conversation on human rights in the country is Nithya Ramakrishnan. She's representing Gautam Navlakha, one of the 5 who are currently under house arrest. Ma'am, thank you very much for being on the show. I think one of the questions that many of us are asking, when these arrests happened, there was a sense of absolute panic, like, you know, when you say multi-city arrests, terror plot, I mean, the kind of language that was coming out, everyone was startled. What happened on the 28th of August?
What happened on the 28th of August was that a set of people across the country, in Delhi, in Hyderabad, in Faridabad and Bombay, were raided and some of them taken into custody.
Right.
That's what happened. See, there are arrests taking place all the while,
Right.
including in terrorist cases. What really shocked the conscience of this nation is the kind of people who were arrested, the kind of causes that they have been known to espouse. These causes are causes of the marginalized, those whom the state may be discriminating against,
Correct.
those who may perceive themselves as being discriminated. There are the plurality of opinion is the bedrock of democracy. So, Sudha Bharadwaj is known to be a trade unionist. She has also represented people accused of terror charges. More recently, she is representing those lawyers who have been picked up on terror charges, whereas all that is known about those lawyers is that they were representing terror accused.
Right.
So, legal representation is a constitutional right. Lawyers do it. And if lawyers who are representing people accused of terror are then brought into the sweep of the terror law, then other lawyers who speak up for these lawyers are in turn brought within the sweep of the terror law. Or human rights activists who raise issues about the nature of legislation or the nature of police atrocities, or who talk about the framing of people just for espousing these causes, or those say who speak about Kashmir. So, the nature of people who were raided this time were not people, say, linked to any particular incident of terror like a blast here or an explosion there, but people who have been known to be outspoken and who have always spoken within the legitimate framework of institutions.
Right.
So, when these people have been arrested, and then it turns out that while securing their arrest, for instance, for Gautam, I can say that they bring a sheaf of papers in Marathi, and it is still not evident what was the basis on which Gautam Navlakha is being arrested. Because what they bring is an FIR of the 31st of December regarding a cultural incident. Apparently, after that incident, there have been some riots.
Correct.
Now, whether those riots are linked with this incident itself is a big issue. But with that FIR in Marathi, you come to arrest a man in Delhi who was not even part of that cultural program. And then you just make a statement that we've added terror charges under the UAPA. A person is arrested in a cognizable case on suspicion. But that has to be credible information. It just can't be that on any information. So, what was that credible information? And what was the information placed before the magistrate for seeking his transit remand? Just to say that he is wanted in a case A or case B, which is a non-bailable case or a terror case or a murder case or a rape case, is not sufficient under the law even for arrest.
So, ma'am, even in the legal system, for all of us, actually this poses many different questions at the intersections of what we as citizens of India have the right to say and to not say, to think and to not think. Now, you talked about the law briefly, that, you know, under the terror law they just come in and by association they are creating this network. But the fact of the matter, the law itself is so flawed on this, right?
See, the law is flawed in some ways, in many ways. But the use of the law in this fashion was not contemplated even when such laws were upheld by the Supreme Court, because it was repeatedly stated when the first terror laws were upheld, TADA, then POTA, that they are meant to target only those activities which the normal law cannot tackle. Of course, many of us feel that there are no activities that the normal law cannot tackle, for the simple reason that a law on terror does not help you prevent an incident.
Correct. Right.
The law kicks in only after you've picked up somebody on the charge. So, once you've picked such a person up, there is no reason why the normal law cannot apply. So, the logic is flawed. But even as it stands, they are meant to be for exceptional circumstances linked to terrorist acts. It is not meant to be used in the fashion that A has been caught in a terrorist case. Now, B is known to A. So,
And
B
so
will now
therefore
be
B is-
caught.
yeah.
Now, C is known to B, so C will be caught, and it is not meant to apply to people who raise questions about the
Correct.
wisdom of this law in legitimate forums. It's not meant to be used against anybody and everybody.
In this instance, when they came on the 28th and they tried to detain these people and tried to move them to Pune, and all of you went to court at that moment to try and make sure that they were not taken, what was the evidence that they provided? On the basis of what had they come to Delhi?
That's a good question. The Delhi High Court asked that question also, saying what according to you, because you bring an FIR saying there was a cultural program,
Correct, right.
and we are arresting this Kabir Kalamanch people. That was 8 days after the program. FIR not by the, some fellow goes and says these people, you know, they are doing something unlawful. Then a bunch of people are arrested. Now 8 months later you come to Delhi to somebody, or you go to who have nothing to do with it. The only material that was brought, as far as I know, as far as been shown, is in Marathi and FIR. Now that does not mention Gautam Navlakha, for instance, nor does it mention a terrorist offence, nor from what I have read of it does it even provide the ingredients of a terrorist offence. Then they say that to this FIR, terror offences were thereafter added. Added on what basis? You can't just add, supposing there is a theft in your house and there is an FIR regarding a theft, and the police just comes and says we have added terror offences and we are catching A, and on the basis of A we are catching B
Yeah.
in a terror offence. Question is, there is a legal process by which, of course, arrest on credible information of the commission of a cognizable offence is permitted. It's permitted even outside the place where the FIR is registered. There has to be that credible information. So, at every level the law provides for a check. Of course, the standards of the check are different. The standards of the check at this point of time may be different from the standards of the check at the same time of framing charge, what you have said at the time of bail. All of this is different, but the problem with terror, so even for ordinary law, there must be credible information that is a cognizable offence. The magistrate must be shown that credible information. In fact, the magistrate is supposed to peruse the case diary.
Right.
And see what is the basis. Some basis to even suggest, and also the reasonableness of that basis for the purpose of depriving somebody of custody. So, just now we are not only judging the basis of that FIR, although as I said, on the face of it, after it's translated, I don't see any ingredients of terror in it.
Okay.
But such as it is, you come to arrest somebody in another city linked to that and further say this is now further a terror offence, should some chapter and verse not be given? It does not appear that any such material is given at this point of time. This much I can see.
So, while this battle is being fought on the legal front, and this issue, it's almost like a fundamental issue about
It's an
evidence.
issue of
that's-
human rights,
that's
an
being
issue of
raised,
liberty.
Right. But it's exactly, it's in a larger issue for all
And
of
the
us.
fact that those against whom this extraordinarily, unwarranted, meaningless, absurd process is being targeted
Yeah.
are persons who have otherwise raised issues regarding the unjustness of the state,
Correct.
the marginalization of citizens against corporate interests, then shows a certain political design to this.
Right. I was just getting to that, because as you all were trying to ensure that transit remand wasn't given and these people were not
Ours
being
was a
sent.
habeas corpus petition.
Right.
It's a tremendous writ.
And
It's
there
a
was this
primordial writ, so to speak.
correct, and the Supreme Court was also hearing.
The Supreme
what
Court, yeah.
they said
Supreme
was an
Court
Article
entered,
32 petition,
later,
right?
that is a group of citizens who were concerned, extremely eminent
and raising
citizens.
these very issues
Saying,
about
what is the political pattern of this?
as lawyers, when we as citizens go to the court and say, what is the political pattern of this? At that point in time, the Supreme Court justices decided to ensure that these people were not going to be taken to Pune, and they have till the 6th of September for the Pune police to come back with more evidence.
In any case, if they had all this stuff, what prevented them from giving it to the court? And from whom did they get it? See, the problem, I want to tell you something is, the kind of things which have become terror offences in this country are A, standing up for arranging legal defence for those accused of terror has become an offence. For calling yourself anti-fascist,
That's
it's
become
an
an offence.
For raising issues about lynching has become a terror offence.
Correct.
So these parameters cannot now be commented upon rationally because it is totally beyond reason. See, nobody is saying now you have a law, you can use it. But the absurdity of the process is in that when you come to seek their remand, you have no material.
Correct,
And
exactly.
when thereafter you come, you say we got what? A pamphlet?
So then in that case, ma'am, my question is, when it was clear that there was no credible evidence when they went to try and
We have not
take
seen
these-
that credible
You have not
evidence.
seen it. Why at that point did the judges say house arrest? Why didn't they just say let them go? And when you come
See,
back
there
with
is
something,
one.
we'll talk about
First,
it
the
again.
Delhi High Court said house arrest because on that day they were supposed to produce to the court on the following day because this came up in the afternoon. Came up within hours of his arrest.
Correct, that's
and
right.
the court acted with remarkable promptitude. That is really the greatness of the writ of habeas corpus and of public spirited judges. The Chief Justice immediately said, go straight to the roster bench. So when I go and say, listen, I am going to be taken away, the state will be asked naturally.
Right.
I am not stamped with DNA that I can never utter a lie, right? The court will ask the other side. When the state came, they said we have arrested them and so we have taken them to the magistrate. So the question arose of the validity of the whole process of arrest as well as that of the magisterial order. So until this comes before a court, how can the court judge? So the court says, okay, come back tomorrow with all the stuff which I can understand in a language, and also question even then arose of what could have been shown to the magistrate when even the High Court was not shown anything in a language that it could read, and the High Court raised the issue, what is the material you have against this person? So it was kept for the next day. And the next day, by the time the court was going to
The
dispose
Supreme
of
Court
the case,
had, yeah. So just a couple of questions. The magistrate who had given this order for the police to come here
Gautam
and
Navlakha's case,
in Gautam Navlakha's case to come to Delhi and take him to Pune, etc.
the magistrate was approached to give a transit
Transit
remand to take
order.
him away.
Correct, right. So, what I want to understand is when you have a magistrate who is presented by any police, in this case it was Pune police, it could be any other state, any other police, saying, oh, we are conducting an investigation into what we think is this larger plot and it's national security.
Whatever
it's
it may be, you will have to show some material that you have on your record to say that A is the person who is wanted.
Right, but the question I want to ask you therefore, because clearly.
And the magistrate is supposed to scrutinize the case diary as it is at that stage.
Correct. So, my question is, why doesn't the magistrate do that?
That is the issue before that you have to ask the magistrate. All I can tell you is that he is supposed to do.
Is there a problem in the legal system?
Of course, he has to do it.
Not just in this case. Is it a larger problem?
I think the magistracy is somewhat divorced because actually the magistracy is the most important unit, because in Delhi you have a high court. What
about there?
What about some place, Jhumri Talaiya, somewhere where there is no high court? It's the magistrate who is the first and primary guardian of liberty.
Right, which is exactly why the question
That is why these questions are important. That's why these questions have to be settled by these courts to reiterate the law as it stands. The constitutional obligations as they stand, they have to be again and again and again recalled to the institution.
So, what is the next step from here essentially? I mean, now that they're under house arrest, I mean 6th of September.
Supreme Court is seized of the matter. The Delhi High Court also halted its order in between out of deference to the Supreme Court. So, let us see how things turn out. Legally, the next step for us depends on what the Supreme Court says.
And can you also give us, for the sake of people who are not familiar with how the legal system operates, the Article 32 petition in the Supreme Court, what it means that the court even decided to, give them the time to hear that.
I have not gone to the Supreme Court, but I have now read the petition. Article 32 is the Supreme Court's not only power, but it's the Supreme Court's duty to intervene when fundamental rights are affected and to reach just injustice wherever it is to remedy it. So the petition that has been raised, filed by Romila Thapar, Devaki Jain and others, Maya Daruwala, Satish Deshpande, Prabhat Patnaik, is that look what is happening to the democratic fabric of this country. It is right to dissent which is being stifled, and that is evident from the people targeted.
Right, absolutely.
And that they have been people known to espouse causes integral to democracy, integral to justice. And suddenly you say here are people plotting, actually you do not even know what they are saying, but whatever is broadly saying that they are terrorists, that means there is some other design afoot which has to be halted here and there. So they have asked for an inquiry into how this happened. They have asked for seeking an explanation from the Maharashtra police for what is happening. And they have also, I think, made the Union of India a party. So it's a very, it's a conceptual, it is raising fundamental issues.
Just as an aside, last week on the show we had a human rights defender from Maldives named Shahinda Ismail who was on our show, and she's been hounded and persecuted by her own government in the Maldives, and she made a very I'm just saying this because it's sort of the links are so apparent, and she made this comment about how we're seeing these patterns across the region with populist governments who are not able to
Populist?
populist governments who are not able to take dissent or take dissenting voices, and how
those spaces are shrinking.
Human rights.
Many others have expressed this in the past in the media. Liberal spaces are shrinking. People are unable to take another viewpoint. Otherwise, how else can a prosecutor come and say anti-fascist front hai? That's an offence.
How can they have charged? And this is not the first time.
There are so many people who are charged with being members of terrorist organizations, and the material against him is that they're trying to raise money for legal defense, which is a legitimate objective. So people are arrested, nobody should raise money for them. Therefore, the notion of what is acceptable and what is not is changing, and these interventions are necessary.
Right.
To prevent thought from degenerating into idiocy, intolerance, and being at plural, as I said, it will strike at the plurality of this nation. Plurality is not only ki koi Tamil hai, koi English hai, and all those songs school kids are made to sing. It is about being able to take another view.
Yeah. Ma'am, thank you so much for being on the show, and we'll talk to you again after the 6th, I think. That's when we're expecting.
Thank you for having me.
Thanks a lot, ma'am.
To receive instant updates on all videos from The Wire, click the subscribe button and hit the bell icon. Pay to support independent journalism. Click the link in the description and choose the amount you want to pay.